Hello, everyone. Thanks for joining us today. After a few-month hiatus from our Dentons Academy webinar series, we hope that over the summer, everyone was able to get out of their office or out of their homes or both and recharge their batteries a little bit. For those of you joining us for the first time, we welcome you. Dentons Academy is a series that we have started this year to bring our clients practical analysis of government contracts related issues. Today, I'm pleased to be joined by two partners in our group, Tom Limmer and Phil Seckman, that have substantial experience on the topics that we'll be discussing today, as well as one of our outstanding associates, Megan Fackler. Each of them will be discussing our experience with some new and recent government challenges on contractor recovery. Prior to getting into the meat of the presentation today, and I'll be quick as we have quite a lot we want to get through, I wanted to note two things. Megan, if you can go to the next slide. First, we will have one more Dentons Academy this year, which will occur in early November. We'll be sending out an invite for that webinar in the not too distant future. If there's a particular subject matter that you would like us to address in November or in the series next year, please reach out to me with those topics and we'll make sure to get those addressed. Second, I need to give my quick spiel on receiving CLE credit for the webinar today. So to receive CLE credit, the webinar window must remain open for the entirety of the program, and it must be the only window on the forefront of your screen. WebEx will detect if you minimize the program or use the computer outside of the webinar software, and it will prevent you from earning CLE credit. One other important note is if you have a New York or New Jersey license, please be sure to listen for the code word given during the program. And when prompted, you will need to enter that code word into the Q&A section of the screen. And if you don't have a New York or New Jersey license, you don't need to worry about that requirement. All right, so for our roadmap today, Tom will be addressing cost reasonableness challenges, including a decision issued at the end of last year, as well as our experience on a recent appeal. Megan will then address some CAS issues related to hybrid and IDIQ contracts. And then Phil is going to close us out today with a discussion on Maro Pacus and the CDA statute of limitations, including a discussion of claim accrual. And one final item, if you have any questions as we go through the materials, please put them in the chat box or the Q&A. And I'll monitor those and raise them with the team as we go through the materials. With that, I will turn it over to Tom.
Thank you, Tyler. Good morning, everybody. All right, cost reasonableness is the first topic. This is a cost allowability requirement that's been around for 75 years, and its requirements have been pretty steady and consistent as far as the regulatory wording is concerned during all that time, except for the change back in the early 1990s as to who bears the burden of establishing reasonableness and whether there's a presumption. So it's been around that long, it hasn't been changed that much. Why are we talking about it? Well, you can go to the next slide, please. The reason that we're going to talk about it, and as Tyler briefly identified, there's been some recent developments regarding cost reasonableness. We start off with mentioning the KBR cases, which occurred a few years ago, which established what was seemingly somewhat of a new baseline for how you establish reasonableness, which is its objective, which means that the government and a court may second guess what a contractor judges to be reasonable. The current environment that we want to talk about is approaches that the government has used in cost allowability cases, both of which we'll talk about, and both of which involve compensation. But it's a government approach in these two areas that the board is proving as of now anyway to be an eager enabler of the government's new use of reasonableness in the testing of whether a cost is allowable or not. Basically, what we're going to talk about today and what you're going to hear is that the board is permitting reasonableness to be raised at any time during a litigation, and we'll talk about what that means and whether that makes sense given the context of the Contract Disputes Act requirement for the existence of a government claim. We're also going to talk about the fact that the board appears to be permitting the use of reasonableness to challenge costs, even when a cost is specifically addressed by a cost principle. And as you all know, the cost principles came into being over the years to address issues of reasonableness in nature and reasonableness in amount of specific costs, where the government wanted to make it very clear as to what the government viewed as reasonable and not reasonable. Despite that, the board has shown an inclination to recognize reasonableness as an additional element of assessing cost allowability, even when reasonableness is addressed within the FAR standards at 31205. Okay, next slide, Megan. The first case that we're talking about is DynCorp. There we go, which is a decision that came out earlier this year. And you can see the citation at the top of the page. But in summary, this case involved a situation where the contractor paid severance payments to a terminated CEO. The severance payments paid to the CEO was calculated as 2 times the sum of base salary and bonus at target for the CEO. The government, the DCMA disallowed the costs based on 2 arguments. One was that severance is a, somebody is typing, please mute. The government challenged the severance cost as a type of wage that's limited by 31256P, the compensation limitation. And the government alternately argued that it was also a directly associated cost of an unallowable cost in part, rendering it unallowable in part under 31201-6D. The DCMA in the final decision did not address reasonableness, although it had been addressed in a DCA audit report. The ASBCA rendered a decision that was focused solely on cost reasonableness, FAR 31201-3, basically ignored the 31201-6D directly associated cost argument and found that and did not address the issue about the cap other than to rule that severance was not subject to the cap. When it looked at reasonableness, what the government determined is that 1, the board had jurisdiction over determining the reasonableness of the severance costs, even though it had not been part of the DCMA contracting officer's final decision. And the board didn't address it. It just says we have jurisdiction. Apparently, the board felt that the facts and the legal arguments relating to a directly associated cost and reasonableness were one and the same. But in any way, the board took jurisdiction, and then the board, exercising great wisdom in a poorly written decision, reached the conclusion that because severance was calculated based on, in part, on wages and bonus that was above the salary cap that was applicable to wages and bonuses, that the amount of severance pay calculated on those unallowable costs were themselves unreasonable because the compensation cap had made wages and bonuses unreasonable over a certain level, which the board said made anything based upon those unallowable costs inherently unreasonable. I think it's interesting. I'll read a quick quote out of this case. In the board's conclusions, it says the statutory caps, what's in 31201-6P, establish the contractor's responsibility to the government and the public at large. Therefore, DI's severance payments were calculated in part using salary and bonus amounts that exceeded the statutory caps. We find that the portion of the severance payments derived from unallowable salary and bonus payments above the statutory caps are likewise unallowable. This conclusion is just common sense. There is nothing magic about a severance pay calculation that converts unallowable salary into unallowable severance payments. Based on that pearl of wisdom, the board ruled that the severance costs were unreasonable costs and therefore unallowable. So this particular case sets a stage for DCAA and DCMA to use this rationale to attack other compensation costs that are measured, calculated, derived, however you want to say it, based upon other types of compensation that may be subject to the compensation cap. And an example of how this is going to be done is the next case we'll talk about. Megan, if you change the slide, please, which is a recent appeal that's still ongoing. And there will be a decision issued by the board once the redaction process has been dealt with, where the board ruled on its jurisdiction in a case involving pension costs relating to a non-qualified defined benefit plan. DCMA disallowed the costs associated with that defined benefit non-qualified plan that were calculated based upon salary. It was, among other things, the amount of the pension benefit was based upon salary paid to the individual. And the government in the final decision disallowed the pension costs related to the excess salary as an unallowable directly associated cost. The final decision did not raise reasonableness. The audit reports did not raise reasonableness. So during summary judgment argument, the government, instead of arguing the directly associated cost argument, raised the reasonableness argument based upon DynCorp and made the argument that because a portion of the pension costs were derived, quote unquote, from the unallowable salary costs, the costs above the cap, that meant that a portion of the pay-as-you-go non-qualified plan costs were also unallowable as unreasonable. Contractor moved to dismiss that argument because it had not been raised in the contracting officer's final decision, and that, the government counsel was trying to interject a new argument into the case that was outside of the ASPCA's jurisdiction. Next slide, please. So what happened is the board denied the motion on the jurisdiction, saying that the material costs, the material fundamental costs relating to the directly associated cost allegation were the same material facts that were being used under 31201-3. So they were really the same claim, and therefore jurisdiction existed. Now, this case may go on beyond this jurisdictional ruling and deal with the merits of the case. And if it does, we'll see what the board does with the merits of the case. But where things now stand relating to this issue of the government using or attacking a cost that is subject to a particular cost principle, such as in the case we're just talking about, the recent appeal, the pension costs are subject to 31205-6J. And that provision says that if you measure, assign, and allocate your costs in accordance with CAS, then those costs are allowable. Is the board going to recognize that that is the judgment about reasonableness in nature and amount that is controlling, or will the board allow the government to pursue its reasonableness argument despite the existence of 205-6J? We'll just have to wait and see what happens in that case. We don't know. But the basic takeaway from all of this is that your compensation costs, to the extent that an agreed to pension plan or any other kind of plan, or your practice or your procedure for compensation has some element in it where salaries, wages, and other items that are subject to the salary cap are a basis of how the other compensation element is derived. The auditors may well attack a portion of that compensation cost as unallowable because it's unreasonable because of the salary cap. Now, I've criticized the logic of this board's decision, and there's a number of things to argue in here, but if you've got the existence of the salary cap where Congress made a decision as to what elements of compensation are subject to the cap and what are not, what right does DCMA have to take that salary cap and bootstrap its way into disallowing costs that are not subject to the salary cap? Hopefully that all gets resolved if this case goes forward. We shall see, but this is definitely a new and disturbing element in the government's use of reasonableness. So I'll turn it over to you, Megan.
Thank you, Tom. So we're going to turn to CAS issues that are specifically related to hybrid and IDIQ contracts that are a little bit, have some nuances to it that aren't applied to fixed price contracts and cost reimbursement type contracts. So just a review of our cost accounting standard exemptions and the standards that surround this. So with CAS, it applies to any negotiated contract or subcontract in which the CAS clause is required, and it's unless an exemption applies. And there's 9 different categories of contracts and subcontracts that are exempt from all CAS requirements. The most common that we see are these 5. So we have the first one, which is the negotiated contracts that are in excess of the TINA threshold, which is currently set at $2 million. Contracts that are types that are authorized in FAR 12-207 for the acquisition of commercial items. And this includes firm fixed price contracts, time and material contracts, and labor hour contracts. And it also would apply to indefinite quantity, indefinite delivery contracts where the task orders issued under that IDIQ contract are using these types of contract types. And we'll kind of get into those a little bit more. And then also firm fixed price contracts that are awarded on the basis of adequate price competition without submission of that certified cost or pricing data are also exempt from the CAS requirements. 2 other exemptions are that any subcontract that is awarded under a CAS exempt or higher tier subcontract, because there's no CAS flow down, and so there's no requirement for subcontracts under those CAS exempt higher tiered contracts to be CAS subcontracts. And then also any specific contracts that the head of the agency has waived CAS applicability. And this is important. So we know that procuring contracting officers are typically the ones that determine if CAS applies when they are when they're issuing out contract proposals, but they do not have the authority to waive CAS applicability. It has to come from the head of the agency. So the reason why we wanted just to review these CAS exemptions is because we want to analyze how do these CAS exemptions affect hybrid contracts and indefinite quantity, indefinite delivery contracts, IDIQ. And so with those, let's start with hybrid. Hybrid contracts are not an official type of contract like firm fixed price contracts and cost reimbursement. Instead, it's more of a construction that we find because the FAR does allow for contracts to include multiple, be a combination of contract types. And so this hybrid that we're saying is in quotes because it's not an official type. But we do see it because we see contracts that have cost reimbursement elements and have fixed price elements, and those will the CAS usually typically will apply to those cost reimbursement type contracts, while it won't apply to fixed price contracts. And so when we're looking at hybrid contracts, we're trying to assess whether if CAS clause is included in that contract, whether CAS would apply to every single element of that hybrid contract, or can we parse out the fixed price elements and the cost reimbursement type elements. So in a good example for what we that we're using to kind of analyze how CAS can for our argument that CAS can only needs to apply to the cost reimbursement type elements of that hybrid contract, but it should not apply to the fixed price elements of the contract is first that contracting officers and agencies cannot, there's a requirement that they cannot get around CAS applicability or exemptions by combining contract types. So that is support for the idea that we should be able to break out those elements within one contract and see if CAS applies or not. And then additionally, when the CAS board issued a new rule a few years ago, making that specific exemption for time and material contracts and labor hour contracts. When the CAS board was issuing this rule, it had a comment responding to why the time and material contracts and time and material contracts should be analyzed and whether CAS would apply to it. And so they looked at the mixed nature and they stated that it's important to examine each aspect of the time and material or labor hour contract to determine if that exemption is appropriate. And so that's additional authority that we can look at those different elements of that mixed type of contract. And they said that we should do this, we should look at each aspect rather than trying to classify the time and material contracts as just cost reimbursement or just fixed price as a whole. And so in analyzing this contract, to prove its point, they looked at the time element and they said this time element is usually composed of fixed hourly rates, which are akin to our fixed firm price contracts, which we know are exempt under the CAS exemptions. And then the material element of that contract, which usually includes direct materials and other direct costs, typically those types of elements are subject to CAS, to reimbursement, and would be subject to CAS. However, the CAS board analyzed it and said that these indirect costs, the material costs under time and material contracts are typically including of indirect costs, direct materials, and other direct costs. And these indirect costs are reimbursed typically at a fixed amount established at the time of contract award. And so they found that the FARP had other safeguards and limitations on the cost. And so that was an explanation for why they believed that time and material contracts as a whole, as a category, should be a new exemption under CAS. When we look at these IDIQ contracts, it's a similar, and so it's different from the hybrid where we have this master contract that is issued and we have task orders or delivery orders that can be placed under it. And so typically, or in order to be binding, these IDIQ contracts must require the government to order and the contractor to furnish at least a stated minimum of quantity of supplies or services. And additionally, the FAR also says with these IDIQ contracts that all delivery orders and task orders are subject to the terms and conditions of this main IDIQ contract. And if there's any conflict between the orders in the contract shall control. We realize that there's two types of IDIQ contracts, and it's crucial to analyze these when we're determining whether a task clause that is included in an IDIQ contract will or should apply to the task orders issued under it or not. And so we have this first type of IDIQ contract where it actually does lay out the prices that should be applied to the orders under that IDIQ. And so that when these delivery and task orders are issued, they're essentially just exercising options under the contract. No new terms need to be negotiated. Prices do not need to be negotiated. And so that's our first type where it looks more like an exercise than an option. We also have we see IDIQ contracts that do not establish prices at the outset. And so this pricing action is actually going to be determined when the agency places the individual task orders or delivery orders. And so in other words, when the IDIQ contract does not establish these priced options, each order under the contract has its own pricing terms. And so that itself, the task order or delivery order, is more akin to its own contract and its own terms will control. And so that goes to when we'll move on to the analyzing, well, what does that mean with the CAS exemptions? And so under this first type of contract that we said was more akin to an option, we have, it's just an exercising of option. Those terms of the IDIQ contract will control each delivery and task order, including CAS if it's applicable to the contract as a whole. And so it's not going to be determined at the task order level. However, under the second type of IDIQ contract that's more akin to a modification, and each task order is a separate contract, the IDIQ contract, if it contains a clause at the parent set, it does not necessarily subject every subsequent order that is issued under it to CAS. And so in this circumstance, we have to determine whether CAS and other contract clauses might apply to each individual order. And that's going to require analysis of each order in determining whether it meets a CAS exemption or not. And in order for this, an order to qualify for the CAS exemption, then even if the IDIQ main overarching agreement includes the CAS clause, it will not be applicable to the task order if that individual task order is exempt. Tyler, I think we'll do some more administrative matters.
Yeah, thanks, Megan. As I mentioned at the beginning of the webinar, we need to take a brief moment to satisfy the CLE requirements by delivering the following code word. So all New York and New Jersey licensed attorneys must type the code word challenge into the Q&A section on the right hand of your WebEx screen. And please make sure to hit the send button so that it registers. In case you missed it the first time, just one more time, the code word is challenge.
All right.
Phil, before you start, this is Tom. I just want to jump in and make one comment about what Megan was saying about hybrid contracts. We've run into a situation for a client, just as an example of the hybrid contract issue, where the contract itself was hundreds of millions of dollars of fixed price work, and there was a cost reimbursement CLIN included, and the cost reimbursement CLIN was, I can't remember the exact amount, but it was like $50,000 or $100,000. And the DCAA has taken the position that because that contract has a CAS reimbursement CLIN in it, the contract, in other words, the entire contract is a cost reimbursement contract. So you don't have any options to argue, for firm fixed price contract limitations. And based on what Megan was saying, we think that that is the wrong analysis. You have two types of contracts in this agreement. You have a firm fixed price contract, and you have a cost reimbursement contract that are combined in accordance with the terms of the FAR. But that is an example of how far DCAA and sometimes DCMA will stretch to try to get CAS applicability in a particular situation.
Yeah, and Tom, to build on that, I mean, why does this discussion matter for contractors? It matters for two primary reasons. The first is measuring what your net CAS covered awards are in any fiscal year, so that you figure out, are you going to cross over your full CAS covered $50 million threshold or not, or be eligible to claim or qualify for elect for modified CAS coverage when you're filling out your CAS cert for proposals. And then second, in the event that you have a finding of CAS noncompliance, in order to measure the impact, you have to identify the impacted or affected CAS covered contracts and subcontracts. So if you have a large IDIQ, for example, with many orders under it, some of which aren't arguably CAS covered and some of which are, this argument comes down to the government taking the position generally that if the CAS clause is in there, the whole thing's CAS covered, every order's CAS covered, end of story. And we don't think the analysis is that clear, but just add in that these are our views as to the correct analysis, what Megan was laying out, not necessarily something that's been, you have to sort of pull together different authorities to establish that that's correct. We think it's correct, but it's not settled. Okay, so thanks, Megan, for that. And we're going to turn now to certain affirmative defenses. And specifically, I'm going to give you a recap of the Maripakis doctrine that came out in 2010. In that case, the contractor was defending itself against a government claim for liquidated damages, and part of its defense, according to the Federal Circuit panel majority, was essentially seeking a time extension or equitable adjustment. So the government wants liquidated damages. The contractor saying this contract deadline should be adjusted, and that would reduce or eliminate the liquidated damages claim that the government was seeking. In what was at the time really a shocking decision, the Federal Circuit panel majority held that the court did not have jurisdiction to assess the affirmative defense being advanced by the contractor because it wasn't the subject of a CDA claim. Specifically, according to the panel, if the defense seeks an adjustment of contract terms, then it has to be the subject of a separate certified CDA claim in order for the board, court, or the Federal Circuit to take jurisdiction over the claim. Now, Judge Newman, in a really scathing dissent in Maripakis, stated that it has been routine in government contracts for contractors and the government to raise defenses against the other side based on the board or court having jurisdiction over the claim. And so, the requirement to request a final decision shouldn't, be applied. It's contrary to the CDA and contrary to precedent and settled law. But obviously, she didn't carry the day in that particular case. And subsequent cases, including the ones noted on the slide, have sought to apply limitations or boundaries around the Maripakis decision. Total Engineering out of the Court of Federal Claims and Jane Mobley are good examples. In those two cases, the Court of Federal Claims and the board determined that the Maripakis decision didn't apply. For example, when a contractor is challenging the facts underlying a government claim, or when the defense being raised doesn't seek monetary relief or any separate contract adjustment. Now, turning to a more recent development, and that is the 2019 KBR decision. In that case, the government was appealing from an ASPCA holding where the government was found liable for about $44 million plus CDA interest in costs associated with force protection that KBR ended up paying under what's known as the Log Cap 3 contract. Now, the procedural history of the case is really pretty convoluted, so I'm not going to bore you all with a summary of that. What I really want to note is that in KBR, the contractor had already been paid the $44 million at issue, and the government recouped that amount by offsetting the alleged debt against other invoices. And this was ultimately, that action of recouping those dollars was ultimately viewed to be a government claim by the board and then affirmed by the Federal Circuit. So the question at issue on appeal was whether KBR could advance a defense, an affirmative defense of prior material breach, and whether or not that type of defense needed to be the subject of a certified claim and a contracting officer's final decision before that defense could be advocated. And the Federal Circuit found that the requirement to obtain a CO final decision applies to certain affirmative defenses, that those that seek an adjustment to contract terms. That's what Maripakis instructs, but the affirmative defense that KBR was advancing in the case was distinguishable from and treated differently from the affirmative defenses that were asserted under the contract as written. For example, the Federal Circuit identifies those common law defenses like prior material breach or fraud as the type of affirmative defenses that wouldn't require a contracting officer's final decision. So building on what Tom was talking about in the cost reasonableness area, where the government's raising cost reasonableness, sort of out of the blue in the litigation, as opposed to it having been the subject of a final decision. The takeaway is that for contractors, if you've got a potential affirmative defense that doesn't seek to change the terms of the contract, then it likely doesn't need to be presented to the CO, but you take some risk. If this is your defense, that could be attacked by the government, and you'll get embroiled in this sort of sideline jurisdictional fight as to whether it's appropriately before the board or not. More importantly, we want to note that the contractors should always be wary of overlooking or missing affirmative defenses that should be submitted as claims. Good examples may be claims arising in the context of a termination for convenience, deductive changes, and other similar circumstances. So contractors and their lawyers need to remain vigilant in this space. And it can be difficult to anticipate at the beginning of a case the various ways that the game may play out and mature over time. So you have to be trying to think creatively about what may happen in the future so that you can best protect your interests. And if the government has asserted an affirmative defense or advanced something that you think is a new claim in the context of litigation, you should be thinking about whether those defenses seek adjustment to contract terms, whether they should be the subject of a final decision, so that you can use the Maripakis case as a sword rather than just always being on the defensive. So Tom, I wanted to see if you had anything else to add here.
Yeah, the only thing I would add here is that Maripakis has created a lot of turmoil in litigations for the reasons that Phil has described. Asserting claims, quote unquote, too late, or asserting claims too early to avoid Maripakis, but there's a lot of uncertainty and unhappiness with what this decision has done to the quote unquote, timely and efficient resolution of government contract disputes. Because of this, the ABA public contract law section is undertaking an effort to, among other things, bring up to the industry with hopes that industry will then lobby Congress to get the impact of this case changed because it creates, how do I want to say it? It creates more gaming in the litigation context than is really appropriate under the general concept that the CDA is supposed to, achieve timely and efficient resolution of claims. So if you have anybody who's involved in the ABA public contract law section or you're interested in it, you may want to participate in this effort. Who knows where it'll go, but it's definitely, at least in our opinion, it's definitely worth it to try to get rid of this ability to game a litigation when there's no real productive aspect to it other than just complicating it.
Thanks, Tom. So now we're going to turn to, I guess, a somewhat related subject in terms of, defenses, the statute of limitations, and some challenges and issues that we've been running into recently. But to set the stage a little bit, wanted to say that, really ever since the CDA was amended back in 95 or so to add a statute of limitations, a key question that contractors and the government have been wrestling with is, when does a particular claim accrue? And to address that question, there are two key issues to consider in our view. The first is a threshold issue, and that is what is the nature of the claim from a legal theory of entitlement perspective, and what is and what is not a claim under the Contract Disputes Act. Now, the CDA itself doesn't define claim, but under the FAR, the term is defined in part, as noted on the slide here, as a written demand or written assertion by one of the contracting parties seeking as a matter of right the payment of money in a sum certain, the adjustment or interpretation of contract terms, or other relief arising under the contract. Now, that's just the first sentence of the definition. The definition goes on to provide that if a written demand is over 100,000, it has to be certified. And the definition also says that a voucher, invoice, or other routine request for payment that is not in dispute when submitted is not a claim. This category of routine requests for payment submissions can be converted to a claim if it is disputed either as to liability or amount, or is not acted upon within a reasonable time. Now, the second key issue, once you've sort of established what's the legal theory of liability and does it qualify as a CDA claim, yes or no, is, well, when did that claim accrue? And the FAR, once again, sort of comes in to provide us a definition, and it defines it to say that accrual occurs on the date when all events that fix the alleged liability of either party and permit assertion of the claim were known or should have been known. And the definition goes on to provide that for liability to be fixed, some injury must have occurred. Now, we think reading these definitions together establishes that a routine submission is a type of written demand for payment that will not and cannot become a claim, and therefore accrual can't occur for as statute of limitations purposes until there is a dispute. So now let's turn to the next slide here. So for those that are familiar with government contracts and have been reading through cases or dealing with these issues for some time, this discussion of routine versus non-routine requests for payment may remind you of the old dispute requirement. You needed to have a dispute before there could be a claim. Now, an en banc federal circuit decision, Reflectone, resolved the issue for most claims by delineating between routine and non-routine requests for payment. The Reflectone case essentially instructs that routine requests are not claims if they're not in dispute when submitted. And a routine request would seek payment under the contract terms, sort of in the ordinary course, and would be a part of contract administration. So it's not just limited to progress payments. There's a federal circuit decision noted on the slide here, the Parsons case, that found that requesting payment for adjusting invoices from a subcontractor necessary to address an issue relating to indirect rates was to be viewed as a form of routine request for payment. So basically, a routine request can be converted to a claim if the government disputes its liability or the amount and basically says, I'm not going to pay until we resolve this. That then becomes a dispute, and then you can convert it into a claim. Now, Reflectone established that for non-routine requests for payment, there must be some expected or unforeseen action on the government's part. And this element of government action or government involvement in some way is fleshed out further in the Parsons Global versus McHugh case, a subsequent federal circuit decision. So that means that the government has injured the contractor in some way, and that ties it to being responsible for the amount being demanded. Again, for a routine request, until there's a dispute, there's no real basis for the contractor to claim injury. They are just submitting their request in the ordinary course under the contract. There's no breach. They haven't been harmed yet. The government doesn't injure the contractor until it has a present duty to pay and then fails to abide by that duty. All of this is around trying to determine, well, when does a contractor's claim, CDA claim, accrue in the context of these routine requests for payment? So let's bring that discussion to a specific example and something that we've been experiencing recently. A question can arise, for example, in the context of a contractor claim for a pension deficit. as to when does that claim accrue under CAS 413. Now, the FAR CAS clause 52230-2 establishes that the contractor is obligated to comply with all CAS. So in the event of a segment closing, a pension plan termination, or a pension plan curtailment, CAS 413 is triggered and would require that the contractor determine the adjustment amount to previously determined pension costs, determine the government's share of that amount, and then make a CAS 413 submission, basically seeking to be paid. So an open question is whether a CAS 413 event itself is the accrual of a claim for CDA purposes, or does accrual actually happen at a later date, namely when the contractor submits its CAS 413 submission. This can be a very important issue because these submissions can take quite some time to prepare. And if a contractor is in a position where the CDA or the CAS 413 submission goes in later, and then the government sits on it, you can run up to, if you were to measure accrual from the event, you could run into a potential government argument that the statute of limitations has been passed if in fact the event itself caused accrual of the claim. So in our view, in the context of a deficit, the CAS 413 submission really most properly is what's viewed as a routine request for payment, that the contractor can't just skip over the CAS 413 process and immediately submit a certified claim. And so such a submission seeking a deficit, in our opinion, establishes an argument that accrual doesn't happen until that date, and so you would measure from then and see whether or not you're past the 6 years or not. There's also issues around equitable tolling and other things, given the Federal Circuit's view that the statute of limitations is not jurisdictional. Now, cases have held that if a contract or a regulation imposes pre-claim procedures, then compliance with those procedures may also delay claim accrual. In our view, CAS 413 also meets that requirement. It's hard to see how a contractor could claim a CAS 413 adjustment without first adhering to CAS 413's requirements. So for all those reasons, the CDA statute of limitations shouldn't accrue or begin to run until that submission goes in. So that is a discussion around routine versus non-routine requests for payment, and thinking more completely about what should go into your analysis as to whether claim accrual has occurred or not based on contractor claims. So I wanted to turn to a more recent case law development in the area of the statute of limitations, and that is the Federal Circuit's decision in Electric Boat. In that case, the contractor asserted a claim seeking increased costs that it had incurred due to its obligation to comply with an OSHA regulation that was enacted during contract performance. The board below the ASPCA found that Electric Boat's CDA claim accrued when the OSHA regulation itself was enacted. Now, Electric Boat had been going back and forth with the government, and also had some issues with subcontractor amounts that it was trying to pull into and include in its claim. But it ultimately argued at the board and then at the Federal Circuit that its claim did not accrue until the contracting officer originally denied its request for a price adjustment, and that happened in May of 2011. So on appeal to at the ASPCA, the contractor was unsuccessful. The ASPCA found that the contractor's claim was barred by the CDA statute of limitations. So the contractor appeals to the Federal Circuit, and the court determined that accrual of the claim in that case had occurred on the date when the government had a performance obligation namely under the contract in that case, there was an H clause that provided for a contract price adjustment for any impacts caused by a change in law. Now, that H clause provided that the price adjustment would occur through an equitable adjustment subject to the changes clause. And the Reflectone decision I was talking about earlier and other cases have established that a request for equitable adjustment under the changes clause is a non-routine request for payment. In other words, you have a government caused injury at the date when the change occurs. Really Reflectone and other cases recognize that this government unilateral right to change a contract is really atypical in common law contracts. And so the equitable adjustment is kind of an organized way for the parties to address the liability associated with what would otherwise be viewed as a government breach of contract, this unilateral change of the contract, kind of similar to what we see with terminations for convenience. Again, an atypical mechanism where one party retains the right to basically just cancel the contract whenever they want at their convenience for any reason or no reason, at least as the cases have looked at the very broad boundaries around the government's right to terminate for convenience. So bottom line, what does this all mean and why are we talking about it? If you're faced with an accrual of claim question, there's different key sub issues that you should consider. The first is, what is the legal theory of entitlement or recovery that you're going to pursue? Does the definition of claim under the FAR, specifically the routine versus non-routine request for payment issue, have an impact? Is there anything in the contract or otherwise that imposes a pre-claim procedure on you that would prevent you from immediately submitting a certified claim? When did the injury occur based on your legal theory of entitlement? All of those factors can impact the date of claim accrual and should impact if you're in a place where you're potentially running up against the statute of limitations, you should be thinking through, how can I articulate my claim and how can I approach pleading in terms of my causes of action to best position myself to deal with any potential threats that I anticipate associated with the statute of limitations affirmative defense that the government may raise. If you're thinking about those things proactively at the pleading stage and at the claim stage, you're going to better position yourself for the potential battle to come down the road. Tom, Tyler, do you guys have any other thoughts to add on that subject?
No, I mean, I think you covered it. I mean, the entire issue of what statute of limitations and claim accrual is gray and still developing. But the criteria that you just laid out to be considered are the best way to deal with it. But it's definitely evolving, to put a term on it.
Yeah, and I think that the Reflectone, Dowco, Sharman, all those cases around the CDA and jurisdictional wickets that you have to get through in order to get before the board of the court really relate to the affirmative defense Maripakis mess that we were talking about earlier. They're all this unfortunate and expensive kabuki to some extent that contractors run into. Now, that's not always the case with the statute of limitations, particularly if the government's claim should be barred by the statute of limitations. Then it's an important boundary that we need to fight for. But I think it does complicate the process of litigating government contracts issues in a way that the uninitiated or inexperienced can find themselves walking into some potholes. So.
If I could, before we end here, I want to go back to the cost reasonableness discussion for just a second that we began with. And the point I want to bring up is something that I thought about sitting here listening to the various discussions and thinking about what I discussed. When you think about what the board said in its DynCorp conclusion, where it says that its conclusion that severance pay that was calculated based in part on salaries and bonus above the compensation cap, the board says that concluding that severance based on the unallowable salary and bonus is also unallowable. It says this conclusion is just common sense. There's nothing magic about a severance pay calculation that converts unallowable salary into allowable severance payments. The thought that struck me is that language, that thought process would support a government argument that unreasonable costs in that circumstance could be deemed to be expressly unallowable and subject to penalties. I mean, I've always understood, and I think a lot of people have always agreed, that if you have a cost that's disallowed for reasonableness reasons, penalties do not apply. But given the board's language about, this being common sense and meaning that it's plain and anybody could figure it out, that starts to track toward the current standard of what is an expressly unallowable cost, which is that there's no reasonable basis that a cost is allowable. To support that something like the severance payments in Doyle might be expressly unallowable cost triggering penalties. I don't think that's right, but to me, that's another potential risk in this area that you should keep in mind, because it's not too long of a jump to go from what the board said in Doyle to arguing that the costs were expressly unallowable. So I just wanted to close on that happy note.
Thanks, Tom.
Okay, we've got a couple minutes left. If anybody has any questions, I haven't seen any pop up, but we'll stick around for last few minutes and happy to answer anything that anyone's curious about.
Well, and
right.
We're always available via email too. If they've got questions, they can follow up that way as well.
Yep, I was just going to say, seeing nothing. We hope everyone enjoyed the topics today, and feel free to reach out to us should you have any questions. And again, if you have any topics that you would like us to cover in future webinars, feel free to reach out to me and we'll make sure to address those topics. So thank you, and hope everyone has a good rest of the day and a good weekend ahead.